Alexandria Ocasio-Cortez made a sincere effort to normalize breaking the law.
Have members here that have submitted and mischaracterized closed-door hearings. So it is understandable why Hunter Biden would want to testify in front of the...
Alexandria Ocasio-Cortez performed Olympic-level mental gymnastics during a heated congressional session to argue that Hunter Biden shouldn't face contempt charges despite ignoring a valid subpoena. Her complex reasoning stretched beyond legal bounds, but Byron Donalds swiftly and decisively dismantled her arguments, leaving no room for doubt.
Gall to come here, show up, and then when the Democrats are saying, hey, he wants to speak, he leaves. This is a joke. This is a farce. The man has been subpoenaed by...
We're not playing partisan games or blindly supporting any party. We're examining the full picture. Our focus is on reason, logic, and common sense, separating the important issues from the noise. Subscribe if you value independent thinking and clarity over blind loyalty. Let's get started.
November of last year, the chairman issued a subpoena to Hunter Biden to appear on December 13th, for a closed-door deposition. Instead of respecting the rule of law, Hunter Biden chose to give a press conference on the front steps of the Senate. If you're a big-name Democrat, then you are immune to prosecution. Former Attorney General Eric Holder said as much in a memo he wrote regarding collateral consequences. For those who don't know, the collateral consequence policy allowed prosecutors to consider whether charging a company or individual will result in greater societal harm than not charging them. It is why Jeffrey Epstein's clients aren't behind bars. It is also the mindset of President Biden and his family. Too big to jail. Not too big to fail, too big to jail. The two-tier justice system is a disgrace to our country and the principles it was founded on.
To put it in perspective, this hearing took place in January last year, yet it remains highly relevant today. The context: as part of the ongoing investigation into President Biden, the House Oversight Committee formally subpoenaed Hunter Biden on November 8, 2012, scheduling a closed-door deposition for December 13th. To avoid potential selective leaks, Hunter announced he would only testify publicly and refused to comply. His lawyers even submitted formal letters insisting a public hearing was the only proper course. Republicans on the committee viewed this as a blatant disregard for the subpoena. With this background, let's examine Alexandria Ocasio-Cortez's attempts to distort the facts.
I may be one of the very few people that actually believes in Congress, in this country. But I do, and many of us do here. And we have an obligation to engage in good faith participation to execute and comply with the subpoena. The chairman said in front of the country several times to Hunter Biden, you can show up here in front of the world, in front of the public. Hunter Biden took him up on that offer. He said, I will show up in public. I will show up in public. He showed up here today. He showed up here.
It's ironic for someone to claim respect for Congress's authority while defending an individual flagrantly violating its rules. Congressional committees have the legal power to determine the terms of witness appearances. While discussion and compromise are possible, the committee, not the witness, ultimately sets the conditions. A chairperson's later media comments on whether a hearing should be public or private carry no legal weight. The subpoena itself is what matters.
Chairman, I know you do your best with what you've got. You've got members here that have submitted falsified evidence to the record. You have members here that have submitted and mischaracterized closed-door hearings, and people want to say back and forth at the end of the day. It doesn't matter what party it's happened from. So it is understandable why Hunter Biden would want to testify in front of the public for the American people to be able to witness that testimony for themselves.
Since Hunter Biden's subpoena specifically called for a closed-door deposition, there was no room for misinterpretation or flexibility. Byron Donalds rejected these evasive tactics and unsurprisingly confronted the behavior directly.
Let's be very clear. This isn't about Hunter Biden's white privilege. It's about Hunter Biden's Democrat privilege. Because Donald Trump Jr. showed up for 5 congressional subpoenas. There was never this circus where he was subpoenaed by House Democrats and he showed up on the Senate side or showed up at the White House to answer in some fake, phony, lame press conference, not actually going to the House and doing what he was compelled by a subpoena to do. Hunter Biden did that. And then he has the unmitigated gall to show up here when we know that we're going through actually the legislation for contempt with, by the way, Mr. Chairman, we should actually get to the legislation of contempt. The speechifying is great, but let's do our business, members.
This isn't new territory. Consider Steve Bannon and Peter Navarro. Both invoked executive privilege, yet were ultimately held in contempt of Congress and jailed for defying subpoenas.
He has the gall to come here, show up, and then when the Democrats are saying, hey, he wants to speak, he leaves. This is a joke. This is a farce. The man has been subpoenaed by Congress. Oh, and by the way, the January 6th committee, Mr. Raskin, which you did sit on, by the way, that was not a normally ordered committee of Congress. Ladies and gentlemen, let's move forward with our business. He should be held in contempt. There was a subpoena. He did not answer it. Any other American will be held in contempt by Congress. Any other. This is Democrat privilege of the highest order. Let's do it.
Congressman Tim Burchett stressed that the perception of a double standard in the administration of justice will only increase if Hunter Biden is not held equally accountable. Political insiders are subject to a completely different set of rules than everyone else.
That this committee will act in a way to negotiate and achieve a compromise with the witness. But if it goes to the court, it's going to present a novel question. What happens when a committee represented by its distinguished chairman goes out in public and repeatedly invites and challenges a witness to come before the committee, and then that witness gives the answer, yes, I will come in? At that point, the committee pulls a bait and switch and says, well, we actually don't want you to come before the full committee as was offered repeatedly in public by the chairman, but instead we'd like you to come to a back room and do it there in a closed deposition.
Jamie Raskin persisted in asking more philosophical and abstract questions in an effort to defend or clarify Hunter Biden's choice to evade the committee's subpoena in spite of all these obvious facts and precedents.